Thanks, Stephen. So I'd like to also express my appreciation of being invited here today. I'd like to not only recognise the traditional owners of these unceded lands and pay my respects, but I also want to recognise those who are with us today who have kind of survived their kind of wrongful conviction. I also want to recognise those people who aren't with us today who have been wrongfully convicted or convicted on the basis of proceedings in Australia that were substantially unfair. And there's a couple of people up there who are in that basket, Sunil Fraser and Lang, as it turns out. I also wanted to say before I start, I'm going to speak in broad terms, maybe a little polemically, which I think is fine for a situation like this. And I also want to say that whilst I wholeheartedly support some kind of commission, and I'd even defer on many points with other people who have more knowledge about that than me, whatever it does, it has to lead back into upriver prevention, because that's where things have to be fixed. People can't spend 10 or 20 years of their life trying to fix one case. It's unworkable as a system. So I've been asked to talk about expert evidence, and I've been working on expert evidence for a long time. And I think I was asked to speak about the finding the right experts, but I think in many ways it's more about finding the right approach to expertise. And often the people that have the right approaches will be the people that will be tightly correlated with the people who are the good experts to rely upon. I'm going to limit my remarks to scientific, technical and biomedical evidence, maybe because they're easier in some ways. There are lots of things we can do, lots of mechanisms, procedural mechanisms for dealing with these things. We can focus on fields, we can focus on training, we can focus on certification, accreditation of labs, research and so on. There's lots of mechanisms that we could look at, legal mechanisms, whether there should be party-based selection, whether it should be court-appointed, whether we should use concurrent evidence, whether experts should testify seriatim. Who gets to decide. I think they're all important, but they're probably less important than focusing on the nature of the expertise, the nature of the knowledge claims that are being made and how they can be sustained or supported. So I'm just going to briefly rehearse our current approach to expertise at law at the trial level. And that's important because I think that's where so many of the problems go wrong, and that's what needs to be revised through the kinds of feedback, systematic feedback, maybe the kind of thing that Stephen was alluding to a little bit at the end there, into the process, because our process is so deeply flawed. And then I'll express some concerns about, I think, our current system as well, and maybe the ability of our current system to actually reform or to learn or take constructive feedback anyway. So in terms of expertise, I'm not reductionist, I'm not kind of essentialist in the way, I'm trying to be pragmatic in the way I'm explaining expertise here. I don't think there are easy ways of identifying so-called good science and demarcating that from so-called bad science. If there were, Galileo might not have been tried. Maybe there'd be more government response to climate change systematically around the world. Maybe we wouldn't live in a post-truth world, but none of those things are true. There is no historical, efficacious, uniform scientific method. Much modern historical science and much modern science doesn't look anything like the way Popper talks about science when you look at it closely. Experiments rarely speak for themselves, but that doesn't mean that we can't generate some kind of useful frameworks and useful criteria, commitments, norms, assumptions and values when we're thinking about how legal institutions, particularly criminal legal institutions involved prosecuting people for crime, should approach expertise. So just briefly, I'm just going to say a few things about the rules that courts have developed. I mean, legislatures as well, but these are really judge-driven. Even the legislature, is profoundly influenced by the judges on law reform commissions, even if they quibble a little bit with some of the wording. Judges develop these rules to identify evidence that's sufficient to go into legal proceedings, so the mechanisms of the adversarial trial could work, and then the fact finders could make their evaluation. So there's a profound confidence in that system, which I'll say a little bit about in a moment. The rules are basically that in a rational system, it has to be able to influence the assessment of facts, evidence. Normally, most opinions are inadmissible, but there are exceptions. There are exceptions for opinions based on specialised knowledge. Bizarrely, lamentably, our courts in Australia have decided that whatever that means, whatever specialised knowledge means, it doesn't have a bearing or doesn't engage with this idea of reliability. And so questions of reliability, the value of scientific, technical and biomedical evidence is really for the jury to determine based on what goes on in particular trials. There's a lot written on mandatory and discretionary exclusions, but they don't lead to the exclusion of that much in practice, particularly the way that they've been eviscerated by High Court jurisprudence. Jury directions and warnings tend not to be very effective, in part because the lack of interest in reliability means that many of the directions and warnings aren't actually based on what might be recognisably scientific knowledge, which is kind of ironic. You go through a performative thing where you feel good about giving jury cautions and warnings, but they're actually not accurate often, or misleading or deceptive at times. Practice notes and codes of conduct aren't admissibility rules, but I should note that in Victoria they've brought in the most kind of onerous practice note in recent times for criminal proceedings, where some of the things that I'm going to mention in a moment exist. I think what's happened is that even though the rules could have been developed in ways that are useful, could have helped out our practice, could have focused on reliability and other criteria I'm going to mention in a moment, they are, as they've been developed, the jurisprudence is unfit for purpose. It's inconsistent in its application, and who knows the effect of these attitudes and these kind of commitments of the judges and the lawyers involved in the system have on the 97 or 98% of cases that never make it to trial, the pre-trial cases and the pleas that come out there where they're not tested. It's crazy. You can't not be interested in reliability. Now, our courts have developed these kind of endogenous models. They're hermetically sealed from the rest of the world in strange ways. They don't engage with the rest of the world, but fortunately there's been a lot of suggestion, recommendations and advice from peak scientific, technical, medical and engineering bodies around the world, repeatedly often advising the courts on what they should do with expertise, what they should be looking for. And so I think these are the sorts of things, kind of de minimis, that courts really should be asking for. What do you need? Well, these multiple reports from the National Academy of Sciences, President Obama's Council of Advisors on Science and Technology, from the National Institute of Standards and Technology in the United States. They speak with one voice, and that voice is really to say, what do you need to do? You need to have, or focus, if you're going to bring evidence into criminal proceedings or legal proceedings more generally even, you need a reliable scientific methodology. That's the first and foremost thing they claim. That's what has been explicitly rejected in our jurisdictions, although it's kind of unified now after the High Court's decision in Lang. The other thing they say is where people are dealing with interpretation, so we're drawing inferences, so we're talking about opinions, you need to be very careful about human factors, about human interpretation and its many surprising and unexpected vulnerabilities. So that's basically it, and I guess I could walk away now. That's what you need. If we paid attention to these sorts of things in a more rigorous sort of way, then many of the wrongful convictions wouldn't be prosecuted. But we haven't done that. There's a lot of emphasis in terms of a reliable scientific method in these reports about validation, about the need to formally test these kind of procedures in conditions where you know the right answer, so you can work out whether the technique works and how well. And the advice is, if it hasn't been tested, don't let it into court. Jurors and judges can't kind of cross-examine them or direct themselves into knowledge. It's not going to happen in a court. It has to happen outside a court. So if you want the kind of quick takeaway kind of version of what the advice is, it's kind of like, ask these questions. Can the person who's offering the opinion, so if you think about Lang, the person who's saying, I can offer some kind of distinction between self-inflicted wounds and wounds inflicted by someone else, can they do it? Can they do that thing? Not, are you a forensic pathologist? Not, have you done 4,000 autopsies? When you do this, how often are you right and how do you know? What conditions? These are the things that need to be asked, and they weren't asked. And so that's one of the problems if you think back to the admissibility standards that are for Australian expert evidence that I mentioned earlier on. After Lang, after 2 trials, 2 appeals from the Court of Criminal Appeal here and a High Court decision, we still do not know whether the forensic pathologist in that case can meaningfully distinguish between knife wounds inflicted by a person on themselves or knife wounds inflicted by someone else. The only thing you need to know to be able to evaluate their opinion. That's all you need to know. Can they do it, and how do you know they can do it, and how good are they at doing it? But no barrister, no judge paid any attention to the most fundamental issue in terms of working this stuff out. These reports have been ignored. There are, the last time I looked on Ostley, there are, out of all the cases, there are 3 references in passing to these. No one's drawing upon them as authoritative, they're just references. 2 of them are just casual references, and 1 is in I think an unreported district court case in Queensland, which cites another case. So think about that. This is mainstream, international, peak, authoritative scientific institutions offering advice to courts, and there's no attention to it, which is problematic. In terms of what we might do or what kind of advice you might want in a for a criminal cases review commission or whatever its name is, I think what you want is some, especially in areas of controversy, especially in areas like, what goes under the name of shaken baby syndrome, kind of abusive head trauma, maybe gait analysis. Maybe what you want is to set up a multidisciplinary group of scientists to talk or to undertake a kind of rapid review, like the Royal Societies of London and Edinburgh did in relation to gait analysis and some DNA, areas of DNA profiling evidence, just to see what's out there, to review the literature and see what's known and what can be done. It turns out with their analysis of the gait literature that really it shouldn't be admitted that was their kind of review. It's not really good enough at the moment. This is identifying people from their movements in CCTV images. That's useful to know, and that should inform practice, ideally. I discussed maybe it was a bit too prescriptive and maybe it wasn't necessarily in the context of a criminal case review commission, but these sorts of things should be undertaken by institutions anyway. Courts should be interested in it. Unfortunately, there's no real structure or mechanism for a court to support it. Law reform commissions tend not to be that interested in kind of individual issues and cases. And even if you do have these reports, how are they going to inform practice? Judges really don't pay any attention to them usually. Maybe that's fair enough if they don't know its authority. Although one of the judges who cited the NAS report, National Academy of Science report in Australia, said that he wasn't, what was he to make of some kind of review from America in terms of understanding the evidence, and he preferred a sergeant speaking about his practices to a multidisciplinary group of some of the most eminent independent scientists on the planet. These are problematic, but we need a mechanism for bringing these things before courts or practitioners, and that hasn't worked as well as we might have hoped. I think multidisciplinary is good. I think because we're just trying to make a quick review of the kind of value of evidence that might be used in criminal proceedings, not to kind of enter the pages of science about the value of this technique. It's not a systematic review or a meta-analysis. It would be quicker than that, although those things can be done, although they're more complicated than you might think in terms of reviewing the literature. I think these could be welcome. They're not necessarily lethal to adversarialism because they're not authoritative and people don't have to defer to them. They just could consider them. But as I say, people don't tend to consider these things or read very much, unfortunately. I think it's important that I say that they should be done by more than one organisation. I mean, I don't want to detract from the Royal Societies. I don't want to detract from the Australian Academy of Sciences, which was instrumental in Kathleen's kind of exoneration, as it turns out. But I think they have their own kind of politics and political story that goes with that, and I think that's kind of slightly problematic for understanding law. And I'll just kind of end my talk on a couple of issues around these 2 points. So whatever form it takes, whatever form the advice that kind of is being used by a Criminal Cases Review Commission, whether it's independent experts, whether it's a multidisciplinary group, or whoever's employed there, you're going to have experts even just to manage the process in an institution. Whatever advice it takes, the important thing is getting it back downstream or upstream to the trial and pre-trial processes and the participants in that system. And there's not much interest there, and that's kind of curious. And so recently I've become increasingly sceptical about the adversarial trial. And I just want to say a few things about the adversarial trial. One is that people celebrate it. They celebrate the features of the adversarial trial. They say, it's got a 1,000-year or longer tradition. And that's really great. But we know very little about the trial and its effect because we don't know whether the people it convicts are guilty or not. It's great to celebrate adversarial proceedings and say, these are great. We've been doing this for a long time. Not many people who have been wrongfully convicted have come forward. It proves nothing. We don't know if the people... there aren't many mechanisms, or haven't been historically, to come forward if you're wrongfully convicted. There's no study. Judges don't study their processes. They don't encourage study of their processes. There's just not much interested in whether the thing works. They don't collect data. It's very difficult, as Rachel would know, and others. It's very difficult even to identify the cases where there have been problems. You crash a helicopter in Queensland, there's a national inquiry down there. And if you do something, if you kind of put someone in jail for 20 years, you just write, this is kind of, we don't interpret the evidence now like we did earlier on. They don't even, as Stephen said, we don't even ask why the interpretation happened at the original time, or whether there might be things to learn. Laypersons haven't performed well, I think it's fair to say, jurors and judges, and that's because often they get pretty limited evidence of pretty limited value. And they're often exposed to untested methods, and they haven't seen that as a problem. Part of the problem of trials and appeals is that they're self-fulfilling. Those who believe that trials work well, those who are involved in this kind of practice as practitioners, become judges and have confidence in the system, and they make decisions, anchored decisions, about whether people who are convicted might be or might not be guilty. They manage it themselves without any knowledge of whether they know whether these people are guilty or not guilty, or have the mechanisms or procedures to actually work that out. It's declaratory, it's just a belief system, and it's circular. I think courts also underestimate the value of investigators on average finding the really easy mistakes. So not that many cases go to trial where it's obvious that the person is not guilty. And that's because it's filtered out. So you have the hard cases going to trial often. There's some exceptions, and maybe child sexual assault is a good example of that. But a lot of these cases, the evidence isn't there. Maybe there was investigative tunnel vision. The people didn't collect the evidence. The leads are lost. You're just rotting in jail, and we can't find anything to kind of contradict the prosecution's version of events, or we don't collect it, or we destroyed it. It doesn't mean that the person is guilty. And also pathological features, which are part of the second or extra appeal rights now, where the system has evolved through judges promoting these as system solutions, where if you think about something like fresh evidence, you rely upon fresh evidence, and then kind of the tortured idea like something being compelling. But if you just think about fresh evidence, they rely upon fresh evidence in a way that means that you don't have to look for the explanation for the original error, because all you have is the kind of new evidence showing that it's all okay. And we couldn't have known. Or we might have been able to know, but there's no inquiry, there's no review ever. And that's a kind of problem. And that's also a problem, I think, with the heroic intervention of the Australian Academy of Sciences, because it was in their interest, I think, to say, we solved this through our members, and they did incredibly good intervention. But that discourages us going back and saying, well, why did you rely upon all this other evidence at the trial? What happened in 2003? Was there enough evidence to really convict the person? What about the appeal in 2005, the appeal in 2007, the appeal in 2021, the first inquiry? Why did these not come up with problems or identify limitations and so forth? And even the 2023 appeal doesn't address why there might have been a problem. It just latches on to fresh evidence, and there's no institutional culpability or responsibility. And so that's a problem. And so these are reasons why, even if we have research and have evidence-based contributions back into the system to change practices, it's not clear they'll be taken up because they're not believed or they're not seen as important by many judges, and that's a problem. And the last thing I want to say, and so it's the blind leading the blind. It's people that don't actually understand their system. They'll declare something is just. They don't understand the system they're using. They understand the procedures and the form of doing justice, but there's no epistemic connect there. And they have not been interested in the effectiveness of procedures or whether they get it right in a meaningful way. And because they're not accountable or checked. And they manage the review process. And that's a deficiency of a naive approach to separation of powers where they've been rendered unaccountable for their behaviour. Bruegel the Elder. And finally, I just want to say, if we're thinking about the Commission and the Commissioners, I disagree with the interim director. I think we need more non-lawyers involved. You need a lot of them because these people, it's easier to learn bits and pieces of law than it is to learn technical complications, statistics, kind of understanding methods and so forth. Anyway, there should be more of them and it shouldn't all be kind of law-driven. I think we need, even for the reform mechanisms, I think you need to, and Stephen was alluding to this as well, engage with the experts so that we can kind of have a process that's more workable from both sides. But it has to be a large part of this, and Stephen was right to correct me when we were talking earlier on, any institution will be valuable, even if it just helps individuals in their individual cases, but there'll be so much lost if we don't use it to systematically study our processes in the ways it can provide, evidence-based systematic feedback and reform. So more non-lawyers, and I'll stop there.